And let's talk about the Fair Labor Standards Act, whether you have to pay overtime, or let me say this, the subject of volunteer workers comes up under the Fair Labor Standards Act, that's the minimum wage and overtime law, because of the fact that many employers, including many churches, try to avoid having to pay overtime by having a worker work additional hours as a volunteer. Many times the worker volunteers to do it. You don't have to pay me. I'm going to work my 40 hours as the church secretary or the church bookkeeper or the church custodian, but I'm going to work another 10 or 15 hours this week. And I know it's a tight time for the church financially, and so don't pay me. I'm volunteering my services. And that's well-intentioned, and that's a noble impulse. But the fact is that the church is going to be potentially subject to a significant liability because the Department of Labor has made it clear you cannot volunteer to perform the same work for which you are being compensated as a paid employee. You can't do it. Now, you can theoretically volunteer to do other types of work, but the more hours you volunteer and the more weeks that you do this volunteer work, the more likely the Department of Labor is going to consider you to be an employee, not a volunteer, for which time and a half is required. And there could be significant liabilities that accumulate quickly. Now, a related issue we wanted to mention briefly is workers' comp. Most churches have workers' comp insurance. Many think that they're exempt from it and don't have it, but that's a huge gap in their insurance coverage, isn't it?
It is. And actually, who are you looking to protect under work comp? Normally the pastor sometimes is the only paid employee or the church secretary. The person that we really want to protect is that pastor, and it provides for medical coverage if he is hurt while on the job, plus it will cover his disability if he's disabled. It will cover his payroll until he can get back up and operational. So we want to make sure that we're covering the pastor. But then you look at, is something covered under work comp? Or is it general liability because there's a fine line? Are they a volunteer or are they an employee? And we've had this happen in several cases. As you know, we did have a church that had a camp, and we had a person injured at the camp, and the work comp carrier said this person is a volunteer.
So there's no workers' comp.
So no work comp coverage. So they denied the claim.
And it was catastrophic.
It was catastrophic. And the general liability carrier said this person was paid something. It was not cash. It was paid something, and we're considering them an employee because basically, if they're paid anything, like you said, lodging, food, any of those things at a camp, it could be considered compensation, and they can be considered an employee. So it's real important. One of the important things to do is make sure that your work comp and your general liability are with the same carrier.
Yes. Yeah, that is so good. So in that case, the fact that the person was paid for 2 hours of work and also received some food and lodging accommodations, there was a dispute whether that was enough to make that person an employee. But it was a big decision, a big issue for the church, because you're looking at a multi-million-dollar claim in that case, and it was eventually determined that the person was an employee. Now think about this. Because the person was an employee, the church's workers' comp carrier provided full compensation and benefits to that person for this catastrophic injury. What if the church had decided, Jerry, like so many, well, we're exempt from workers' comp because we're a church. We're not going to have workers' the church would have borne that liability itself, multiple millions of dollars, because it didn't have the workers' comp. So the point is this: we're talking about volunteers here, and workers' comp. Why we're bringing up workers' comp? Because that deals with employees. That's right, it does deal with employees, not volunteers. But the term employee, and here's the point, is interpreted very broadly in every state, so that many people who you think are volunteers are going to be deemed to be employees. And if they're deemed to be employees, your general liability policy, one of the first exclusions is for injuries to employees in the course of their work, because it's assumed that you have workers' comp to cover that. And if you don't have workers' comp, there you go. You got a big hole in your coverage. So assume that the term volunteer is going to be interpreted very broadly in the context of workers' comp. That's a reason among others, while you need workers' comp insurance.
One of the things, too, that happens is that under work comp, in some states, you can actually add volunteers under your work comp so you don't have any questions whether or not there is coverage.
That is an excellent point.
We do have some questions, and if you do have a question, you can actually type it at the bottom of the area where you're looking at the screen, and type in your question, and we'll get to your question. We do have some questions, so I just figured
before we get to those, let me just mention one other
Okay.
thing that occurred to me earlier, just before our broadcast today. One other issue that I think that I get asked this all the time, especially during the holidays. We're going to give our volunteers at our church a gift certificate to Starbucks or somewhere else, or we're going to give them some kind of in-kind compensation, a turkey or a ham or something like that. Is that taxable income? And I'm asked this all the time. And the answer is yes, it's taxable income. But if that person is not a paid staff member, you don't have to add it to a W-2 because they don't get a W-2. It's a matter of issuing them a 1099, which is only required if you pay them over $600 of compensation during the year. And we're talking $5, $10, $20, maybe $50 in these cases. So you're never, or very rarely, are you giving $600 or more of value to a volunteer as a token of appreciation. So in that case, while it is taxable income, and you might share that with the employee, with the volunteer, it's totally up to that person to report that that benefit as additional taxable income on his or her tax return. You know, are they going to do it? Are they going to report a $5 Starbucks card? That's not your problem. That's up to the individual.
It must be that you're reading somebody's mind, because actually one of the questions are, do gift cards count as compensation?
Well, you see, Jerry, I learned long ago that a good attorney not only anticipates the questions that are going to be asked, but anticipates the answers to be given to those anticipated questions. So there you go.
Yeah, actually, we did have two questions.
And let me make this observation. Yes, there is something called a de minimis fringe benefit under Section 132 of the tax code, which says that if an employer provides de minimis benefits to an employee that are so administratively difficult or impracticable to determine their value because they're so small, you don't have to report that as taxable income. The examples are fruitcakes, hams, and turkeys given during the holidays. That's right in the regulations. But that doesn't apply to any gesture or token whose value can be readily ascertainable, the regulations say. That includes a gift certificate. So if you get a $5 gift certificate, that is taxable income. And if it's an employee, you accumulate that on their W-2. That's not de minimis. But if you give that same employee a box of donuts, that's not taxable. I wrote an article on this once called Donuts Yes, Gift Certificates No.
Well, and actually, so we answered the question, do gift cards count as compensation?
Yes.
What about a volunteer appreciation banquet given in their honor?
Oh, now there you go. That's a good one. Volunteer appreciation banquet given in their honor. I think a reasonable argument there can be made that it falls under the token benefit exception. And there are tax court cases that have reached that conclusion, such as an office party to commemorate the retirement of a worker. There's a case that directly addresses that's the kind of thing that is considered to be a de minimis fringe benefit. It's not regular, it's not periodic, it's not the weekly lunch for the staff that you all go out to restaurants and eat and consider that's not a business expense. That's a taxable benefit because it's recurring, and the bottom line is this: why couldn't you perform that work at church? Why couldn't you have your business discussions in the church, in a church office somewhere? So that's why that's a different case.